Hi everyone. So let's start in 5 minutes. We have attendees already, so they're starting to come in. Everyone.
Hello, can you hear me now? Hello. Okay, is this better? Okay, all right. Thank you for those who responded. Oh, okay. All right. Welcome, everyone. So, welcome to our free webinar entitled Remote Control, Privacy and Data Protection in the New Normal. So, the shift towards flexible work arrangements such as remote work, or more popularly known as the work from home arrangement, has become a necessity for most organizations' business continuity. Employees are forced to work using unsecured networks while accessing important corporate and personal information. This pandemic, however, did not only caught us by surprise, but also ripped open every company's data security defenses. Hence, a data breach is not indeed anymore a matter of if, but more so of when. Also, we have to remember that although most of the companies or most of the operations have been put to pause, we have to remember that the Data Privacy Act was never, the implementation of the law has never been um, put to pause as well. So we have to learn how to make sure that the current processes that we have adopted in this new normal is protected and secured. Without further much ado, let me introduce to you the panelists in this webinar. So first, let me introduce myself. I'm May Ann Garrido. I am the Corporate Services Consultant of Barrozo Law. And we have here as well our founder, Atty. Melvely Barrozo. Sorry, she just got disconnected, but she'll be with us in a few minutes. And we also have our special counsel for data privacy and Fintech, Attorney Guada, Vergel de Dios, and she will be introducing to us our guest speaker this afternoon. Attorney Guada.
Thank you, Anne. So, good afternoon to everybody.
Attorney Guada,
Hi, can you hear me?
It's on mute.
Hi, can you hear me? Hello? Okay, that's better. So, good afternoon to everybody. I'm actually very excited to introduce our guest speaker today, not only because she is a good friend of mine and we've known each other since freshman year in UP, but more so because over the years, I've seen her duly earn that reputation as one of the leading VPA experts in the Philippines. Attorney Maria Cecilia Soria is a Philippine licensed lawyer with core practice in data privacy law. She was one of the first data privacy professionals in the Philippines when she started her consulting practice in 2017. She holds a Certified Information Privacy Manager certification from the International Association of Privacy Professionals and is currently head for regulatory and case management of the PLDT's group's data privacy office. Since putting up her data privacy practice, Cecilia has been helping top Philippine corporations in setting up their privacy management program. She has spoken on data privacy at several conferences, such as the PH TestCon 2017 and the 2017 Philippine Data Privacy Forum hosted by the Asian Legal Business. She developed and offers the Data Privacy Bootcamp, a training program that equips teams working in data privacy with the knowledge on the compliance requirements and the framework to execute this knowledge within their organization. Cecilia graduated from the University of the Philippines College of Law in 2016. She also holds a Bachelor of Arts degree in Political Science from the University of the Philippines, Diliman. Cecilia honed her skills in the practice of law as a member of 3 prestigious law offices, the Medialdea Atabello and Guevara law offices, SGV and Company, and the Tan Venturanza Valdez law offices. She has managed public companies, including established mutual funds. She has also served as corporate secretary and assistant corporate secretary of various publicly listed and public companies, including the country's largest non-bank remittance company, as well as one of the fastest growing thrift banks in the Philippines. Most recently, Cecilia served as assistant corporate secretary and legal counsel to the Philippines' oldest insurance company. From 2013 to 2017, Cecilia was part of the digital transformation team of one of the biggest companies in the country. Since 2012, Cecilia has been engaged in advancing the freedoms guaranteed under the Bills of Rights in cyberspace. She was a founding member of democracy.net.ph, the group that drafted the Magna Carta for Philippine Internet freedom. The bill was adopted and filed in the Senate by no less than the late Senator Miriam Defensor Santiago. Cecilia's digital rights advocacy has taken her from the halls of Congress to international forums. Cecilia spoke on digital rights at the 2015 Internet Governance Forum in Brazil. In 2016, Cecilia was part of the delegation of the American Bar Association Rule of Law Initiative to the 2016 Internet Governance Forum in Mexico. Most recently, Cecilia was part of the 2018 Citizen Lab Summer Institute on Monitoring Internet Openness and Rights, a series of intensive research workshops hosted annually at the Monk School of Global Affairs, University of Toronto. Ladies and gentlemen, let's all welcome Attorney Maria Cecilia Soria.
Hello everyone. Good afternoon. Thanks Guada for the for the introduction. Um, um, People might expect I'll try to live up to the expectation. So, I see that we have a lot of participants. So, thank you for joining us. It's always a good time to talk about data privacy because this has become such an important part of our daily lives, not just in our work, but also in our personal lives. As we continue to keep on having our lives become more and more integrated online. And actually, during the lockdown that we experienced, we saw how rapid the shift was from our offline / analog world to a more online existence. So for today, I will be talking about privacy and data protection in the new normal. The title is Remote Control because it looks like that is what we will need to be doing in the near future. As not all of us are able to go back to our offices, we will still keep on working remotely, whether at home or whether in other offices, temporary offices that we are able to do our work. We will always need to have these controls to ensure that information is protected, to ensure that privacy is respected. But that is the challenge. So for today, I will be talking about the I will be talking about data protection. Okay, so let's go ahead. I'd like to ask everyone if you can see the slides. Sorry. Okay, so there's a rapid shift, like I mentioned earlier, on a remote work model. And there is always a challenge because people have been observing that cybersecurity issues have become more important. For instance, ISACA, which is an organization of information security professionals, have seen that many companies are seeing an increase in the number of cyber attacks since the pandemic began. In a survey that they conducted among their members, the International Association of Privacy Professionals also saw that 48% of their members was of the opinion that safeguarding against attacks and threats have become more of a priority. In addition, the OECD also came up with a report titled Dealing with Digital Security Risk During the Coronavirus Crisis. And in this report, they said that malicious actors are actually leveraging the epidemic to make their attacks more successful. So what are the instances that the OECD has noted? They've noted that cyber criminals are actually counting on the likelihood that the epidemic will make their attacks successful. They have done this by using, for instance, COVID-19 in the subject matter of the email. They see that more and more people are likely to open emails when they see that it is about COVID-19. Other cyber criminals have resorted to registering Zoom accounts. So what they do is they put the word Zoom in the URL, thinking that they will be able to fool people into believing that that website is actually an official Zoom website, and then they will be able to get the credentials, for instance, usernames, passwords of those people who visit that website. So the question amid all of these uncertainties is, what can the organization do? So what can companies do? First, you can conduct a privacy and cybersecurity health checkup. So what does that mean? You can try and see if your policies are still up to date. You can try to see if, I don't know if you conduct tabletop exercises about breaches or about other security incidents. You can do that as well and see how resilient your systems are against cybersecurity attacks. You can also review all of your privacy and information security policies and see if they are still current, or they still are able to reflect the new normal, right? So I know that a lot of us wrote our privacy and information security policies with the assumption that we will be doing a lot of our work in the office. But now that most of our workers are doing their work from home, how does this change the security posture of the organization? So take a look at your policies and see whether there needs to be revisions or it needs to be updated. Second, third, you can take a look at your device use policy. So it was an experience for a lot of companies that when the lockdown was initiated, they were caught flat-footed. None of us actually expected that the lockdown would last for more than 2 months, right? So a lot of the companies actually just sent their workers home, and they were not able to prepare. So when it started to dawn on them that the lockdown would take a bit longer than they initially expected, there was a scramble to equip the workers with devices so that they will be able to work at home. So a lot of the companies actually were forced to allow their employees to use their own devices. So now, given all of these circumstances, we need to take a look at our device use policy. Because I bet that our device use policy, if we do have them, was also drafted under the impression that workers will be using company-issued devices and that they will be doing their work at home. So now that we are allowing our workers to use their own devices, maybe there's also a need for us to revise our policies. Okay, number 4, there will probably be a need to take a look at our user authentication processes again. So, of course, it's a very different situation when it's your employee that is inside the office connecting to the office network and then logging into your databases, logging into your servers, versus a worker that is at home. So, a lot of companies rolled out VPN access for all of their employees, but it doesn't really end there, because even if you have VPN, they will still be using their usernames and passwords. So what are your policies for authenticating that the person trying to log in into your system is actually your employee, right? And then we also need to update our breach and security incident response plans. So when there is a data breach, the challenge now is how to bring all of your key people together to be able to talk and plan about the company's response to the breach or to the security incident. And then, if you are going to do your meetings about the breach or security incident online, how will you ensure that there are no participants that are not authorized in your meetings, right? So you may inadvertently be sharing information about your company's security systems with unauthorized individuals if you are not able to ensure that only the authorized participants in that meeting. And then another challenge in regard to breach and security incident response is how do you conduct your investigations when your key personnel are not in the office? So if there is a breach, will your personnel be able to do the breach investigation remotely? Or do they need to actually be physically in the office to be able to do that? So these are the things that we need to plan for. And finally, we also need to prepare our employees. So what does preparing your employees mean? It means considering whether there is a need to have webinars like we're having now. Do you want somebody an outside resource person to come over and talk to your employees about the things that they should watch out for? Or you can also consider having awareness training sessions, right? So there are a lot of companies I know who actually purchase the LinkedIn learning accounts for their employees so that the employees will be able to continue with their training, even if it's not in the usual classroom setting, even if it's in a virtual setting, and even if they're all not together in one room. And finally, you can also consider having regular email updates, regular alerts, even having infographics that people can save on their devices and that could serve as a ready reference in case they need to check something about the company policy. So there are a lot of things that you can do to actually increase awareness of your employees. Okay. Now, a lot of people are actually using video conferencing facilities, right? To be able to have meetings, to be able to have webinars. So, NPC released its PHE Bulletin number 12. So if you want to take a look at that, that bulletin actually gives some tips on how you can ensure that your video conferencing is secure. So some of the tips given by the NPC are, as much as possible, do not use free accounts. If you can, it would really be ideal if your company would get an enterprise account so that everybody can use. Second, have your meetings set by default so that unauthorized persons will not be able to join your meetings. And then require passwords from participants. And then this also goes into my earlier comment about the need for user authentication. There should also be a way for us to verify the identity of each participant. And then finally, institute controls in the recording and screen sharing so that you will ensure that only those authorized individuals are able to make a recording of the meetings. Okay, but aside from these things that you can do inside the company, I'm sure that you're also looking at whether you need technology or you need new software to be able to really work remotely. So in that case, what would be ideal is for you to be able to conduct a vendor privacy and security assessment. I'm sure that under normal times, we actually conduct this already, right? Especially if it's a purchase that will really be used for extensive processing of personal data in the company. But with the new normal, we are not able to follow our usual processes. And actually, because of what I mentioned earlier is the mad scramble to be able to prepare for the lockdown, there will be times when, as right now, you will need to expedite this process of assessment. So what can you do in conducting your vendor privacy and security assessment? So take a look at privacy documentation. So the vendor should be able to provide you this. Now, if they're not able to provide this, try to go online and see if there are available documentations on the product that you can check. And then it would also be ideal if the vendors that you will get have certifications or trust marks. Locally in the Philippines, it's not there is no organization right now that is doing certification or giving out trust marks when it comes to privacy. But I think the information security certifications are more mature. So maybe you can also take a look at that, whether there are certifications on information security compliance. Take a look at whether they have ISO certifications, for instance, especially the ISO standards relating to data protection. And then also try to do an online search. I usually do this when there's a product that you want to buy. Just try to Google common issues or common complaints, and then put the name of the product. So you can also do that when you're doing security assessments for your company. So do an online search of credible issues, because usually people have this tendency, right, to write about their experiences. That is actually the experience with Zoom. So a lot of people, when they started using Zoom, not a lot of people were aware of the privacy issues or the privacy weaknesses of Zoom, but because a lot of people were writing about it, so people also became aware. And because of the increasing awareness of people, this also put pressure on the company to be able to improve the data protection features in their product. Okay, and then internally, what can you do? Also try to do a privacy impact assessment. So again, this will be a challenge because your team is working remotely. You may not really be able to do a walkthrough, a physical evaluation of the product or the hardware. But this is something that you should also consider doing, maybe just tweak some of the processes a little. And then it would also be ideal if you have a standardized data processing or data sharing agreement for your company. So personally, in my line of work, I also do a lot of contract reviews when we try to engage service providers or vendors, right? So as much as possible, we really try to insist that it will be our contract templates that is used. So why do we do this? It's actually easier for you to monitor, to ensure, first of all, that all of the products and services that you avail of are compliant with your policies in the company. And second, it is also easier for you to monitor whether certain commitments are being complied with if you have your template, right? So you don't really need to change the way that you monitor per vendor or per provider because you're using your template. So I know, of course, there will be some changes because the vendors will, of course, have comments or proposed revisions, but it will really be good for the office or for your company if, on the whole, you're able to maintain your standardized template as the contract that is signed between the parties. Okay. Aside from the cybersecurity issues, what we have seen also is that the sudden and unprecedented shift from offline to online has led to an increasing collection of personal data of employees. So the collection is actually twofold, right? The motivation is one for health monitoring, because we know that since COVID-19 is a highly contagious disease, there's really a need to take a look at whether your employees have the symptoms, and if they do, who they are in constant contact with. And another concern relating to monitoring is also the productivity monitoring, right? Because when we work in the office, the supervisors actually see their subordinates in the office and whether they're working and whether they are able to meet the targets and come up with accomplishments. But when people are working remotely, that can be a challenge, right? So, okay, let's talk about health monitoring first. So the DTI DOLE came out with interim guidelines on workplace prevention and control of COVID-19 issues. And these interim guidelines were intended to provide safety and health standards. So I'm not sure if all of you have already started having your employees return to the office, but a lot of companies are requiring employees before they enter the office premises to usually have a temperature check, and then usually the employees are also required to fill out a questionnaire about how they are feeling, if they have symptoms, if they have contact with suspected, probable, or confirmed COVID-19 positive people. And aside from that, there is also a need to have your visitors or your customers screened, right? So a lot of companies, now that they've started to have their employees go back, are faced with a dilemma in terms of how do I comply with the requirements of the law, requirements of the government, in this case, the IATF. And then, of course, as I mentioned earlier, there's the requirements, the guidelines issued by DTI and DOLE. And then there are requirements also of local government units, right? So they have, they usually ask for data on your employees before you will be allowed to reopen. There are even some local government units that I heard that were saying that if you are not able to submit the personal data of your employees, we will not give you your business permit. So, of course, if you're a company, you become concerned about what are the implications, right? Can you even challenge the data collection that they're doing? And or do you take the chance by just complying, but then what about if the employee complains, right? So one of the topics that have been the subject of a lot of discussion a few weeks back was whether companies are required to do a COVID-19 test for all of their employees before their employees go back. So the initial understanding was that yes, a COVID-19 test was required. Then eventually the government clarified and said that no, it was actually not mandatory. But despite the fact that the government doesn't require it, some of the companies have actually required the employee to undergo a COVID-19 test and for the employee to test negative before they will be allowed to go back to work. And this has also been a challenge. One of the questions that you need to take a look at here is how do you do the checking of the symptoms of the employees? Some companies have and are currently using forms, right? They ask their employees to fill out forms. Some companies are saying that they will resort to soft copies because they think that when they use soft copies, they will be able to control, they will have more control on who has a copy of the questionnaire, right? So versus a hard copy when it can easily be lost. So all of these decisions are decisions that a company needs to make, but it will also be a decision that will depend on the resources that are available to the company. So having employees fill out questionnaires on soft copies of questionnaires may be good for your employees, but what if you will require it for your customers, for your visitors? Then it may no longer be feasible. And it will also be difficult for companies situated in, if it's a company that's just a mere tenant in a big building where there are a lot of companies that are also operating. So where do you start screening, right? Inside the office, or should it be in the lobby, etc., etc. So these are the questions that you will need to think about and you will need to decide on. I think what we need to remember, though, when we do health monitoring, is we need to think about our basis for doing so. So when it comes to health monitoring, since this is a requirement of the government, right? So the reporting of COVID-19 positive employees are a requirement of Republic Act number 11332. So the lawful basis there is compliance of the law. So it's not the consent of the employees. But then the requirement of a company to test all of the employees will now become tricky when it comes to testing, to requiring all employees to do a COVID-19 test. Because as we discussed earlier, the government already said that this is not mandatory. But can a company make it mandatory? I will say that yes, a company can make it mandatory and cite legitimate interest, right, as a lawful basis, because the company also has a legitimate interest to ensure that all of the people working within its premises are not afflicted with COVID-19. Why is there a legitimate interest for the company to do this? Because then it can ensure that not all of its workers will get sick, and therefore the company will be able to continue engaging in its business and servicing its customers. But what happens if an employee will say, okay, I know that it's a company policy to require all of the employees to take a COVID-19 test, but it's not a requirement of the government anyway, so I will say no. So what do you do then, right? So these are the questions that need to be reflected in your privacy notice. Okay? So even if you do not require the consent of an employee for some of the health monitoring that you do, you still need to reflect in your privacy notice why you are doing it, what are the information that you will be collecting, who among the employees in the organization will be able to view that information, until when will the data be retained, how will the data be disposed of. So what we need to remember here is that health information is sensitive personal information. So this is given more protection by the Data Privacy Act compared to the regular, quote-unquote, personal information, right? So by default, processing of sensitive personal information is prohibited unless it is allowed by law. So, and then you take a look at the section on the criteria for lawful processing of sensitive personal information. So all of those things will need to be reflected in your privacy notice, and the privacy notice needs to be communicated to the employees. And then finally, you also have to make sure that even if all of you are working remotely and it's just a skeleton workforce inside the company, that your company will be able to respond to any employee that wants to exercise their rights. So ideally, you will also include in your privacy notice a statement on what data subject rights are available to the employee and the contact details of the person from whom they can raise these rights, ask questions, and file a complaint if that is what they want to do. Okay, next we go to another type of monitoring that's also being done, and this is productivity monitoring. So why are a lot of companies tempted? Okay, so not a lot of companies are doing it right now, but a lot of companies are actually starting to be tempted to do productivity monitoring. Why is this? Because they want, as I said earlier, to replicate the offline operations that they had before, right? How do you convince people that it's business as usual? How do you also assure yourselves that your employees are doing what they're supposed to be doing? Okay, but same as in health monitoring, there may be instances when we are able to do this, but we will need to take a look at our purpose. So what is the purpose for the productivity monitoring? So is it because, for instance, you have certain targets and you want to ensure that your employees are able to meet these targets, right? Let's say the employee should be able to encode information from hard copies of application forms into an office database, right? So, for instance, in a day, you need one employee to be able to encode 50 forms. And you want to ensure that this is done, right? So what is the best way for you to be able to accomplish that purpose, right? So what type of productivity monitoring will you do? And then, based on your purpose, take a look at your metrics. So what you want to do here is to be able to check if the 50 forms per day is accomplished, right? So what are the information that you need to collect to be able to assure that, right? Collect only the information that you need. So if you need to verify that an employee is able to include 50 forms, you don't really need to be able to monitor the desktop of an employee, right? You don't really need to be able to take a look at what the employee is typing at any given time. And then, same as with the health monitoring, this will also need to be included in your privacy notice. And then finally, there will also be a need to take a look at and decide on accountability and consequence management. So when we say accountability and consequence management, what do I mean by this? So accountability means who will be taking charge or who will be accountable of any personal data that will be collected and processed when you do your productivity monitoring. And then for those employees, okay, so that's one. And then second, for accountability management is whether you have policies in place to ensure that not only do these employees who are accountable follow those policies, but what consequences or what penalties will be imposed by the company if they don't take accountability or if they do not comply with those policies, right? In some of the companies that I've been able to interact with, I've noted that there are problems when it comes to consequence management. So, it's not really, while we have penalties provided under the Data Privacy Act, I think it has also been a challenge how to translate the offenses in the DPA and the penalties provided there into policy inside an organization, right? For some of the companies that I've seen, sometimes the offenses, the data privacy offenses that they have in their code of conduct or in their code of discipline, it's too broad that it could actually cover different types of offenses, right? So that is one of the, I think, challenges so far when it comes to implementing data privacy in organizations. Okay, aside from productivity monitoring, another thing that we see now as we go into the new normal is the need to share or submit data not only with government but also with third parties. So, can we submit personal data of employees, especially their health information, with the government? This has always been a constant question that the NPC has been faced with, right, since the start of the lockdown. In fact, the NPC has already issued several bulletins. You can go to the NPC website at privacy.gov.ph and take a look at all of the bulletins issued by the NPC. The NPC has also issued FAQs on the submission of personal data to the government. And so there is a recognition that, yes, the law actually mandates certain instances where you need to submit information to the government. But as the NPC noted, there is a need when you're submitting information and if you're processing information to really ensure accuracy of your data. As the NPC said, data quality is vital to effective contact tracing, right? So contact tracing only works if a lot of people participate. And if a lot of people also submit truthful information. But they will not submit truthful information if they do not see that the company is able to take care of their data. So, and then, of course, if there's inaccurate information, then we are not able to trace, we are not able to prevent and treat those people that need to be treated, right? So, inaccurate information undermines the overall aims of the government to trace. And it also misdirects the government efforts, right? So, instead of, actually, this happened in a company where my friend is, a friend of mine is working. So, the company conducted a contact tracing initiative internally among the employees. So, my friend was identified as a person with whom a COVID-19 positive person had close contact with. So, when she was informed, she already started crying. She was nervous because she didn't know how she would be able to deal with it, how she would be able to isolate herself when she has children, who will take care of her family, etc., etc. And then it turns out that it's just a person with the same surname and the same nickname, but it's actually a different person. So, but because of that experience, you can see that this will likely breed a reluctance in my friend to be more forthcoming later on when it comes to submission of her details, right? Because she has already been burned. And that is a natural human reaction. That's something that we can expect from people. So there is really a need to maintain data quality when we are collecting and processing information. So now let's talk about data sharing with the government. So as I mentioned earlier, Republic Act number 11332, requires the mandatory reporting of persons with infectious diseases. Now the question is, to whom should you make the report? The law states that the report should be given to public health authorities. So who is a public health authority? It is the Department of Health, and it is also the local public health offices. So when it comes to the LGU, you do not really submit information on who is COVID positive to the office of the mayor. No, you go to the city health officer, to the municipal health officer. That's the requirement of the law, right? And as a supplement to the requirement of the law and to the other issuances that the IATF has come out with, the Department of Health and the National Privacy Commission came out with a joint memorandum circular. It's number 2020-002. So I really suggest that you take a look at this memorandum circular, because this will give you more understanding, not just of the procedure for contact tracing, but it will also give you more understanding on how to approach data collection that is being done by local governments, data collection that is being done by other entities as well. So this circular, what I've noticed from it is that aside from putting in the guidelines on how to handle and process personal information in relation to COVID-19 reporting. What's significant here is that the circular itself states that it will serve as the privacy notice of the local and national public health authorities and the DOH partner agencies. So, I was surprised when I read that because, of course, one, not a lot of people will read the circular, right? Especially ordinary people. So, does this mean that local government and the particular offices of the DOH and the particular offices of the partner agencies are already exempt from coming up with a privacy notice? So personally, I don't agree with that. I believe that these agencies need to come out also with their own privacy notices. Why is this? Because they are what data they collect is different from what other government agencies are collecting. So their purposes are also different, right? And these are things that the people, the data subjects need to understand. So I think that notwithstanding the statement here in the joint memorandum circular that this will serve as the privacy notice for the national and local public health authorities, I think that for purposes of really faithful compliance with the Data Privacy Act, that the individual offices also need to come out with their own privacy notices. Okay, so I think you'll also be wondering, I just want to go a little bit into a discussion of contact tracing, just also to give you an idea of what information you need to submit. Okay, so what is contact tracing? The guidelines define contact tracing basically as the identification, listing, and follow-up of persons with close contact of confirmed COVID-19 cases. So it is identification, listing, and follow-up. So that's contact tracing. And this gives you an idea that this means that you just actually need the name and the contact information, right? So that in case news of, in case somebody in your company or in your area is identified as a COVID-19 positive person, so that you will be able to contact the people who were in close contact with that COVID positive person. You need the names of those people and their contact details. Ordinarily, you will not need other information. At some point, like if these people turn out to be positive later, then they may be required to give more information to the government. But for the purposes of contact tracing, you just need to be able to identify these people and have a way to contact them. So, what's curious for me is if you go to the DTI, DOLE, sorry, I have it here with me. So the DTI DOLE interim guidelines on workplace prevention and control of COVID-19. This is something that I mentioned earlier. There is actually a health checklist that you can see in the last page in the annex of the interim guidelines. And if you take a look at it, the health checklist covers a lot of details. So not only the symptoms, but whether they've been in close contact with a COVID positive person, also asks for the residence, also asks for the sex and the age, and the company name and company address. So you really need to take a look at whether if you're just trying to monitor the visitors in your office, do you need all of this information? The fact that it's in the DTI DOLE interim guidelines might give people the impression that all of these fields are actually mandatory. But if you take a look at the wording here in the annex, it says that employers may adapt the sample protocol. So this is just a sample protocol, and the employers are actually not prevented from coming up with their own. So since ultimately you will be, as a company who is the one collecting this information, ultimately you will be the one accountable, right? So even if there is a proposed template from the government, take a look at whether you are comfortable with collecting all of this information based on your purposes. So you can actually remove some of the information that you think will not be um, relevant to your purpose of checking the symptoms and of maintaining a list of the visitors for future contact tracing in case any of your employees or any of their fellow visitors turn out to be COVID positive. Okay. So, aside from data sharing with the government, there is also a requirement of data sharing with the local government. So, I've actually already mentioned this earlier that what I've noticed is a lot of local government offices are actually requiring employers to submit so much personal data of their employees as a precondition for allowing resumption of their business. So some of the local government units that I've seen were asking not just for the names of the employees, they're asking for the addresses, they're asking for the age, the sex, asking for information on the work shift. So hindi bawal, right? So you can actually go back to the local government and ask them why they are requiring this information. Okay, hindi bawal magtanong. You can definitely go back. Because if the local government will say, the amount of information that needs to be submitted will depend on the amount of on the purpose of the local government, right? So if the local government says that the purpose is for contact tracing, then maybe the age, then maybe the sex is not required. And actually, in the first place, even if it is for contact tracing, I would ask whether I need to submit all of that information to the local government. Because you have to remember that when you process information, you should only it will depend on on where you will use it, right? So if it's for contact tracing, the contact tracing information only becomes relevant when there is already a reported case of a COVID-19 person, right? So, and hence that gives rise to the need to contact the people with whom they have been in close contact. But without a COVID positive person yet, I would argue that the local government doesn't really need to see the information on where the people live, how they will be contacted, right? So certainly, as a preparation for contact tracing, your company may collect it, but is there really a need at that point without having a COVID positive person? Is there really a need at that point to share the information with the local government? Maybe not. Okay. There's also a case that I came across with where one local government unit was requiring all of this information. And so what the company did was the company went back to the local government unit and asked them the specific purpose for why they are requiring the information. And the LGU came back with the response that they need it because they need to be able to determine from what areas the people going into their LGU come from, right? So I guess the rationale for this is that if the LGU finds out, for example, just an example. For example, there's another outbreak in Quezon City, right? And then the LGU finds out that a lot of, let's say this is Makati, just for the sake of discussion. So let's say that Makati finds out that a lot of the businesses in their area employ people coming from Quezon City. And there's an outbreak, there's a new community outbreak in Quezon City, then that will certainly be a source of concern for Makati, right? But if that is the purpose, the Makati LGU doesn't really need to know the apartment number, right? The building name, or even the street where the employee lives, right? So this is how you calibrate the information that you collect vis-a-vis the information that you submit to the local government unit. Okay? So as a reminder, we are not, I would like to cite this NPC Advisory Opinion 2018-070. Okay? So what the NPC is saying here in this opinion is that yes, the local government, they have the mandate to collect certain information. But even if they have the mandate to collect information, that doesn't really mean that they no longer need to comply with the Data Privacy Act, right? And we know that the Data Privacy Act requires that if you process information, there should be transparency, legitimate purpose, and proportionality. So in the case of our example, there may be legitimate purpose because the LGU wants to have information of from which cities and municipalities people who are going into that LGU are coming from. That's certainly a valid purpose in order to be able to plan, right, their health response. But when you take a look at the principle of proportionality, then you may have questions on whether giving the complete address of the employee is still required if the purpose is only to know from which municipality or city they come from, right? Okay, so next, we have also seen that there are a lot of companies that have been sharing data with third parties. And the privacy guidelines say that disclosure to the public, to the media, to other public-facing platforms without the written consent of the patient or the patient's representative or next of kin is prohibited. Okay, so there is no leeway that is being given in this joint memorandum circular. It explicitly says that the disclosure is prohibited. So one example that you may ask is, a few weeks back, there was, it's not a case, but there were news reports and a lot of people were concerned about the Philippine Coast Guard's decision to make available the quarantine certificates of those the overseas contract workers who went into quarantine. So these are actually seafarers, I think. So when upon their arrival in the Philippines, they had to go into a 14-day quarantine, right? So after, and I think they also were required to be tested for COVID-19. So after the testing, there was supposed to be a quarantine certificate that was issued. So the aim of the Coast Guard was actually laudable, right? It was valid that they wanted to be able to find a way to immediately give the seafarers a copy of the quarantine certificates. Except that the method that they used raised a lot of concerns from a lot of privacy advocates. What did they do? They made available online, specifically on their Facebook page, links to a Google Drive, which had all of those quarantine certificates. So even if, apart from the name of the seafarer, what was revealed in those, in the information that they made available through that Google Drive are the names of the employer or the company to which that seafarer belonged, and also the fact that the seafarer tested negative for COVID-19. Okay, so some people might say, but what's the issue? I mean, it's not a positive result, right? No, because even the negative test result is still health information. And as we all know, under the Data Privacy Act, so health information is sensitive personal information, and the default is that sharing of that kind of information is prohibited unless it is allowed by law. Okay, so again, I would like to stress that the Joint Memorandum Circular is very much explicit in the requirement that disclosure to the public, to the media, and to other public-facing platforms without the consent of the patient is strictly prohibited. Now, okay, before we end, I would also like to cite another example where there have been data sharing with third parties. So in planning for the pandemic, there are a lot of research groups as well as some government agencies who actually did mobility studies because they were trying to look into whether the lockdown is successful in limiting people's movements. So they asked for information from companies that had data on the mobility of people. So what type of companies can this be? The telcos, of course, because by the what do you call this? The aggregated cell phone signal, so they will know if there's a lot of people in certain areas, and they will know the patterns of movement of these people. And I think another company that was tapped for the studies that were done are companies like Google, right? So Google owns Waze, Google has Google Maps, so they have mobility information of people, and these companies were requested to share their information. So the question that arose is, can they do that? Yes, they can do that, but in so doing, they really needed to comply with the Data Privacy Act. And the requirement is that take a look at the purpose for the request. And if it's like in this instance, right? So the purpose is just a study of the mobility pattern. So you don't really need to know who is going where, right? You just need to know the trends for certain communities. So you can do that. You can share information in an aggregate manner, but make sure that it's anonymized. So anonymized doesn't mean that there's no name attached, right? So even if you don't know the name, you can still determine who that person is, either by their numbers, either by whatever code name you use for that person. So anonymization actually requires that that person can no longer be re-identified. So anonymization, sharing of anonymized data is allowed because anonymized data is no longer considered personal data, right? Simply because you can no longer link it to a particular person. So if it's no longer considered personal data, the Data Privacy Act no longer applies. Okay? Okay, so and finally, before ending, I would also like to quote again one of the IAPP report on privacy in the wake of COVID-19. I think what struck me here in this report was this conclusion by that study. And it says that privacy is actually here to stay. Kasi, diba, our question is, can we still go back to the old ways or are we stuck with the new normal? So when it comes to privacy, the IAPP study says that privacy is here to stay, but what's significant is that they say it will re-emerge as a new type of privacy. So, what is that new type of privacy? It's something that we will still be discovering in the next few months. But what's exciting, I think, here is that this will really require us to be more innovative and will also require our government agencies, particularly the National Privacy Commission, to be more forward-looking and see whether there are new policies that they need to come out with in order to reflect the new normal with a new type of privacy. So with that, I would like to end my presentation. Thank you so much again for your participation. And I think we will have time to take some questions.
Hello? Yes. Hi, Ces. Thank you very much for that very informative knowledge sharing and how companies should ensure that it balances data privacy, compliance, and business viability. So these are really very practical advice that corporation grapple with the onset of COVID-19 and force these companies to employ work from home among others. So I think we have some questions from the attendees. Let me start reading some of them. So first one from the chat group is let me see. I think this is really not in relation to the current situation, but a general question about data privacy. So a question from Miss Jean Gregory. The question is, where do you think data privacy officer should be placed in the organization?
There is no specific requirement, right? But the advisory, okay, but this is just an advisory that the NPC came up with. They said that ideally, it should be somebody of VP level because you need a person that has sufficient leeway in and authority in making decisions for the company. And based on experience and what I've seen with other organizations, it's also ideal that the data protection officer has a certain level of independence. Why is this? Well, because management, since management is responsible and accountable for the operations, there is also a tendency for management to be more defensive of their actions and of their policies, right? You can't really take it away from them because everyone is human. So ideally, you are able to empower the DPO to make decisions and to be able to give their views with independence. Of course, as a caveat, I also would like to say that it doesn't actually mean that, that the company will be forced to follow whatever the DPO says, right? Because after all, there's still an established decision-making framework within the organization. So certainly, the DPO can give recommendations. Management can disagree with what the DPO says and take their own action. And conversely, there will be times when the management takes its own actions and the DPO disagrees, right? But whatever it is, I think what's important is for the DPO to be able to document whatever decisions or recommendations he or she makes. Not just as a way of, not just as for documentation's sake, but mainly because the DPO will not be there forever. So if there's another DPO or if there will be other staff inside the data privacy office, they will be able to inform themselves why certain decisions were made a certain way, why certain actions were taken. So parang it's also institutional memory, but you're putting it on paper so that everybody will be able to refer to it in the future. Oh, and it's also good pala in cases of NPC investigations. Diba? So may artifacts kang ipapakita.
Yes, that's correct. Thank you very much, Ces. Moving on to the next question from Mr. Mark Alfred. What are the penalties to those companies or even individuals violating data privacy? And how do we deal with it? I guess coming from a data subject perspective.
So there are different types of penalties that the Data Privacy Act itself provides. So there's criminal penalties, which means that you pay a fine and go to jail. There are also civil liability attached. This means that if there is damage to data subject or because of your violation, a company suffered damages, then you will be asked to reimburse, make whole the person who was affected. And then there are also administrative penalties. So when we say admin penalties, what this means is the NPC can issue an order telling you to stop processing And depending on the type of business that you have, this can be very debilitating to your business or can actually be fatal to your business. Case in point is there's a big fast food chain that a few years ago received a compliance order, a cease and desist order from the NPC. So they were forced to shut down their delivery website. So you can just imagine, right? A fast food company without a way for people to order via the website. That can be a big blow to your business. So it's actually a good thing that they sell food. Because imagine if if it's a company that processes information as a major part of its business, right? So that will actually force you to close your business if you get a cease and desist order. I hope that answered your question.
I think that's sufficiently answered. And I know that fast food chain. I love that fast food chain. So another question. Few countries have regulatory frameworks in place to support the extraordinary contract tracing and population-wide surveillance. So I know that you already mentioned some of the laws that the Philippines currently has, but do you think that there is a need to revise some of the data privacy provisions so it can capture this kind of scenario?
As of now, I think, for one, the NPC has, I think, been very diligent in coming up with guidelines and advisories to enable people to deal with the uncertainty that we face now, right? Especially in terms of contact tracing, etc. Is there a need to revise or to amend the law? I think that in respect of our specific situation, I think the law is sufficiently general that it will allow us to comply with the requirements of the law while still we are able to do the reporting and we are able to do the contact tracing. I think that based on what I've seen, I think people have the Tagalog word is parang natitigilan, right? They have doubt when they see the requirements. But I think that once you take a look at why the requirements are in place, once you're able to understand the consequences for the data subjects that will be victimized, I think you will be more prepared to really comply and just go through all of the processes that you need to go through, so you're able to protect the data subjects' rights. So, kasi the information, especially in this case, information of whether a person is COVID positive or not, can really give rise to discrimination. Not just discrimination, it can also mean, like in my story about my friend that was informed that she had close contact with a COVID positive person and then it turned out to be another person. It gives, there's emotional anguish, there's, very real and significant effects on the person. So, yeah. But apart from that, so there are actually moves for coming up with more harmonious policies on COVID-19. So, for instance, globally, there is an effort among data protection authorities to take a look at the response of governments to COVID-19. Luckily, it's actually this effort to review is actually headed by our privacy commissioner. So, si Commissioner Libora was recently named as the head of this COVID-19 task force, which is an effort of data protection authorities. So, yes, there is an effort to take a look at the policies and the compliance. So, there's that.
Okay, thank you very much, Ces. Then I think I have time for 3 more questions, Ces, if it's okay.
Okay, no problem.
So this one, from an anonymous, from somebody anonymous. So what about those COVID-19 positive who are public figures and who confess to the public? Will that mean they waive their privacy under the law?
Okay. Actually, the making available of information publicly is what do you call this? It's actually been always a source of contention. So when it comes to privacy, okay. So in general, the rule is that, and this is also related to when you post something on social media, right? So in general, the rule is there's a more limited privacy protection if you are the one who divulge your personal data in public, right? So if I post something on Facebook about the fact that I am a COVID positive person, then I cannot expect people to not discuss, right? The fact that I'm a COVID positive person. So if there's a personal data I posted online, like where I work, my age, etc., etc., so people can actually process that. What makes the difference is when it is repurposed and when people try to profit from that, for instance. So, okay. So, for instance, there's a celebrity that said, I'm a COVID positive person. Will that mean that a company can therefore scrape all of Facebook and make a list of all of the people who said that they are COVID positive people? And then, let's just say in the future that there's a special type of medicine that is developed, right? So is it then proper for the company that after this publicly available information was entered into a database, this company contacts all of these people and says, oh, I'm offering you this product, buy this, because I'm offering it because I heard that you said that you're COVID positive. In one of the advisory opinions, the NPC actually said that you can't do that, right? So there's if you deviate a person who posts something on social media posts it for a specific purpose, and a company cannot repurpose that and then use it to do marketing, to do profiling, etc., etc. So that is prohibited.
Thank you. Says this one from Mr. Dios Tumeldan.
Yeah.
Are companies required to hire a data privacy officer?
Not all companies are required to hire a data privacy officer. So, let's go back to first principles, diba? So, the Data Privacy Act covers processing of personal data. So, if in your company, you do not process personal data, you are not covered by the Data Privacy Act. So, and if you're not covered by the Data Privacy Act, there is no requirement to hire a DPO. That's the general rule, okay? The NPC already came up with an issue once where there are certain types of companies where a DPO is mandatory. So just take a look at the privacy.gov.ph website. It's there. Okay. For everybody else, it's voluntary. However, especially for companies who may not be in the mandatory list, but who are actually doing a lot of data processing, it is always good to have a DPO, because then you know there's somebody who's really taking a look at whether or not you need to comply.
Thank you. Okay. Thank you very much. I think that's the last question that we do have. So, Ces, salamat.
Thank you.
Enriching to have this session with you. So, I turn the floor over to Miss Anne.
Thank you. Thank you,
Princess.
Thank you. Thanks for having me.
Yes. So for any additional questions that our participants or viewers have, please send them to our email, info@barrozolaw.com, and we will try our best to answer them all. So
Also, the
Also, the
Facebook
Facebook
Live.
Live and the YouTube video of this webinar will be available in our page and channel on a limited time. So make sure you are following our pages and get our updates. Okay, so now as we end this session, let me turn over you to our founder and principal, Attorney Melvely Barrozo, for her closing remarks.
Okay, thank you, Anne. Thank you also to our resource speaker and subject matter expert, Attorney Soria, for sharing her knowledge and valuable insights on this very relevant and timely topic, given the new normal that we are facing or we are in now. So, data privacy and protection, and as well as data security, are not just the roles or responsibilities of a data protection officer in an organization. So it's everyone's responsibility to protect the privacy and the security of the data that we are processing in our organization. So we hope that you learned or you get useful tips from Attorney Soria's presentation this afternoon that you can apply in your organizations and in your work. With that, thank you again, and we hope to see you in our future webinars or events once this pandemic is over. Thank you again.
Okay, thank you very much for your presence here in our webinar, and we'll see you again in our next event, hopefully. Bye.
Yes, thank you, Mel. Thank you, everyone.